another scholarship highlight brought to you by the Center for Firearms Law at Duke University School of Law. This series is a part of the Center's broader efforts to deepen the scholarly discussion of firearms law by engaging directly with some of the many scholars who are doing important work in the area. I'm Jake Charles, Executive Director of the Center, and this week we're joined by Greg Wallace, Professor of Law at the Campbell University School of Law. We're going to be talking with him about his article, Assault Weapon Lethality, forthcoming in the Tennessee Law Review. Thanks for being here, Greg.
Thanks for having me.
Of course. So first, just in a nutshell, can you tell us what the article is about?
Well, you often hear assault weapons described as weapons of war, uniquely lethal, designed for quick and efficient killing. Well, this article provides an evidence-based assessment of the claim that so-called assault weapons are far more lethal than other firearms. That claim drives both pro-ban narratives and court decisions upholding assault weapons bans against Second Amendment challenges. Now, if that claim is false, if assault weapons really are not more lethal than non-banned firearms, then I think gun control advocates and courts are going to have to find other justifications for supporting or upholding laws that keep such firearms out of the hands of ordinary citizens. I examined two main arguments for the exceptional lethality of assault weapons in this article, what I call lethality by analogy and lethality by metric arguments, and I find them lacking. They amount to little more than proof by assertion based on unsubstantiated claims by ban advocates, by federal agencies justifying their policy decisions, and frankly by individuals who have little or no experience with how these banned firearms operate. Now, I want to be very clear, nobody wants firearms in the hands of terrorists or criminals or the mentally dangerous, but I don't think assault weapons bans are the solution. The perception that the problem of mass public shootings lies more with the firearm rather than with the shooter, I think, obscures the complexities that surround such shootings, and I think really diverts the attentions of policymakers from more effective solutions.
So what was it that kind of led you to think this was something that you needed to write about right now?
Well, it began with my first read of the D.C. Circuit's decision in Heller 2. There were claims about the operation of AR-15s, and I'm going to use the AR-15 as substitute for assault weapons. I don't want to get into defining assault weapons, but most of these bans are aimed at AR-15s, which is the most popular rifle in America right now. But the DC Circuit's decision made claims about how the AR-15 operates that really did not square with my own experience with these firearms. For example, you can empty a 30-round magazine in 5 seconds, which would require you to pull a trigger on the AR-15 6 times in a single second. I knew that that's not something that people generally can do. I decided to write the article after reading the Fourth Circuit's en-banc decision in Colby 3 years ago. Again, what stood out to me were the factual errors, like the AR-15 can fire 300 to 500 rounds a minute. They pose a greater danger to the public because of overpenetration through walls. These and other factual inaccuracies also appeared in the most recent federal court decision, the First Circuit's decision in Werman, including citations to newspaper articles describing the massive and devastating wounds that are supposedly created by AR-15s. So I think the factual inaccuracies that did not square with my own experience was the thing that got me very interested in this subject. Now, I don't expect judges or law clerks to be firearm experts, but I do expect them to engage in a rigorous and independent review of the relevant facts before drawing their legal conclusions based on those facts. And I think a lot of the debate over assault weapons is driven by both ignorance and emotion, and I'm trying to change that.
Yeah. So who would you say that your you're primarily engaged with this piece. What scholarly discussions are you joining? Are you directing the piece mostly at these judges who are going to be deciding the constitutionality of such laws, or legislators who are considering whether to enact such bans, or other scholars or lawyers making the arguments, or their law clerks, as you just talked about, or all of the above?
Well, probably all of the above. With respect to the scholarly conversations, Joseph and I have had some wonderful private conversations about assault weapon bans. I think there were two articles about assault weapons in the spring volume of the Harvard Journal for Law and Public Policy, but there's just not many scholarly conversations
Yeah.
about assault weapon bans right now. That's probably because with the string of 5 federal court decisions all upholding various assault weapon bans, a lot of people, I think, perceive that the issue is simply off the table. But my view is that these federal court decisions are deeply flawed, both factually and legally. I'm starting with the factual basis for these decisions, and then we'll move on, I think, in a subsequent article or two to the legal arguments. So, yeah, I think judges, I'm very surprised, and the people who've read this article have almost all told me that they are very surprised that the judges in these decisions have embraced these factual inaccuracies as a basis for their decisions. I think that goes to the legitimacy of those decisions. I'm also aiming this at litigators, people who will be litigating future cases, again, so that hopefully there will be some good facts for them to use in this. I still see erroneous claims about the operation of assault weapons being made in not only briefs from state attorneys generals who are defending these laws, but also in amicus briefs made from by Everytown, Brady, and Giffords. So, yeah, I'm just trying to bring some factual light on the issue and make it something that is fact driven rather than emotion driven.
Yeah. So one of the things you talk about, I guess, kind of earlier in the article, is about how rifles in general, or long guns in general, and kind of the AR-15 in particular, are rarely used in crimes, rarely used to injure or kill other people. And I just wonder about what you make of this kind of notion that counting the number of casualties, people hurt or injured, the number of times it's used in crime, might understate the amount of societal harm that these weapons do cause when they are used in rare events like mass shootings. So, if it turns out that that a community and that the nation as a whole feels a lot less security when there is incidents in which AR-15s, say, are used in high-profile mass shootings, is that anything that you think should be taken into account in the calculus, or kind of is it not a really legitimate basis on which legislatures can base laws like this?
Well, the Seventh Circuit in the Friedman case actually relied on that justification as one reason for upholding the assault weapon ban there. I think there are social costs in the exercise of any number of constitutional rights. A guilty criminal may be released because there was a Fourth Amendment violation. First Amendment protects offensive, demeaning hate speech, which makes people feel terrible. And so I'm not sure that the social costs that are imposed on people by having these guns within the community is necessarily a relevant consideration. Now, what my article does is to demonstrate that these AR-15s, they're certainly lethal. Every gun is lethal. That's part of its core function. And in some way, they are more lethal than some weapons, less lethal than others, but that they are not exceptionally lethal. They're not lethal as As the federal courts have said, they are not lethal far beyond other firearms. So I'm not sure that that social cost calculus should figure into the Second Amendment decision making here. If it does, then I think you also have to figure the social cost to those people who are deprived of being able to have those weapons available for their own self-defense if they think that they need them.
You mentioned these two arguments that you set out to challenge in the article: the lethality by analogy, that these are weapons of war similar to the M16 or M4, and the lethality by metrics, that these weapons are, higher rate of fire, do more damage to the body. Which of those two arguments, kind of the data argument or the weapons of war argument, do you think is playing a bigger role in, in public support for these bans, in judicial decisions, in legislative decision making? Ask you to play sociologist a little bit to see what you think the bigger role of these arguments is doing.
Well, I certainly haven't done any scientific study of that, but my perception is that when it comes to politicians, policymakers, um, advocates of assault weapons ban, that the analogy to military weapons is probably most often used. You repeatedly hear the claim that AR-15s are military weapons or military style weapons designed for use in combat to kill a large number of people on the battlefield. I think with respect to courts, if you look at the five leading circuit court decisions here, the Heller 2 decision, the NYSERPA decision, the Friedman decision, the NYSERPA decision from the Second Circuit, the Friedman from the Seventh Circuit, the Colby from the Fourth Circuit, and the most recent Werman in the First Circuit, you will see that the arguments that drive the analysis there are more of the data type arguments,
Mm-hmm.
the rate of fire, the damage in terms of what happens when one is hit with a bullet fired by these weapons. So I think probably because the argument by analogy to military weapons is easier to state. It's more conducive to a sound bite. I think that's what you see mostly within the sort of popular promotion. The more a little more sophisticated analysis that the courts are doing are more a little bit more data driven.
That makes sense.
Just not with the correct data.
Yeah. So let me drill down in this lethality by analogy argument. So you talk a lot about the M16, M4, and about the military's use of them and some of the military's complaints about ammunition used in them, and compare them to the AR-15. And tell me if this is wrong, but it seems to me that the main difference, maybe the only substantial difference between the two, between the military and the AR-15, is that the military weapons have selective fire capabilities so that they can fire in automatic mode, semi-automatic mode, and maybe in burst mode as well. And I just wonder if the reason that the civilian AR-15 does not also have that capability is because of a pre-existing regulatory regime, namely the National Firearms Act, that would have classified the AR-15 as a machine gun and heavily regulated it and now banned new ones. If it had that selective fire capability. So in other words, do you think that it matters at all, and you can feel free to push back on the premise here, that it matters at all that kind of the choice of this AR-15 as a self-defense weapon is itself already kind of determined by the background regulatory landscape that was in existence at the time?
Well, certainly that plays a part, but I think it really has more to do with function than the law. A fully automatic mode is not particularly useful for self-defense or target shooting or hunting. And one of the reasons is that obviously it is a very dangerous type of it's automatic fire is a lot harder to control, and so I think the difference there, I mean, if fully automatic weapons were suddenly legal today, without all of the hoops you have to jump through under the NFA, I'm not sure that uh, people would rush out to buy them
Yeah.
for serious purposes of self-defense or target shooting or hunting. That would certainly multiply the number of videos on YouTube with people going on there and showing how they're shooting in full auto.
I had the
But
same thought.
yes, it's just not practical, I think. If you look at military doctrine on the use of fully automatic fire. It's more of it's the exception rather than the rule. The M4 and M16 soldiers are trained to fire them on semi-automatic mode 90% of the time. But the reason why you have fully automatic capabilities, first of all, a military squad will have a machine gunner, somebody with the M240 or some other fully automatic weapon that really is capable of sustained fully automatic fire. But the idea of having fully automatic fire in an individual soldier's combat rifle is primarily for use in gaining fire superiority over the enemy. And so it's not something that is terribly practicable for individual self-defense or target shooting. Or I mean, they might be fun to shoot, but they're very dangerous. Perhaps you saw the video a few years ago, the tragic video of the man who took his young sons to a gun range that was having some event where they were allowing people to fire fully automatic weapons. And he let his 9-year-old son, and the range officer there was not properly trained, and the son pulled the trigger, and the gun came back and actually shot him in the head because of the recoil. He couldn't manage the recoil. Tragic situation. And so I think there's an argument there that fully automatic firearms are unusually dangerous, and therefore that's why I think there's been no serious constitutional challenge to the NFA's regulation of them. But I would say probably it has more to do with function than with the legality.
So let me ask you a question then, since we just had the Supreme Court's decision in June Medical released earlier this week, and we're recording this the last week of June and the first week of July here. I want to ask about an analogy between abortion restrictions and, say, an assault weapons ban. And follow me as much as you want to, and feel free to reject the analogy at any point. But if we can assume that, I would say that your paper supports the notion that an assault weapon ban would be ineffective because these weapons are just not any more lethal or deadly than regular other semi-automatic weapons. If we assume that, say, the restriction that the Supreme Court struck down in June Medical, an admitting privileges requirement for physicians, is also ineffective, I just wonder what your thought is on, is that the end of the constitutional inquiry? You can't have an ineffective law that affects a constitutional right. Or do we have to move on to another step there and say, what's the burden on the right? Chief Justice Roberts, in his separate decision, in his separate opinion in June Medical, said, actually, we just do a substantial obstacle inquiry, and we say, what's the actual burden here on the right? And I wonder if you think there's something similar to be done with assault weapon bans. Do we look at whether this is actually a substantial burden on the exercise of self-defense rights, or is it enough to say this is an ineffective regulation and it touches the constitutional right, therefore it's forbidden?
Well, I hope to have a future article on the legal standards that are being applied to assault weapon bans and to really address that very good question. I think there are different standards, there are different constitutional standards with abortion, the undue burden standard,
Yeah.
where the Supreme Court in Planned Parenthood versus Casey sort of rejected the tiers of scrutiny and now analyze abortion restrictions under the undue burden standard, which does focus on the burden there. In my view, both the effectiveness of the regulation and its burden on Second Amendment interests are part of the means end fit
Yeah.
that have to be assessed under the tiers of scrutiny, assuming the Supreme Court doesn't issue a decision in the next, we thought it was going to be this year or next,
Yeah.
but it looks like maybe 3 or 4 more years out, perhaps. Assuming the Supreme Court leaves that two-part test that's common in the lower courts in place, I think both the effectiveness of the regulation and its burden on Second Amendment interest are part of this means and fit. Obviously, there's going to be, whether at intermediate scrutiny, an important or substantial state interest, or even at strict scrutiny, a compelling interest in public safety. The real where the real decisions are being made about these assault weapon bans and other gun regulations are in the narrow tailoring, the tailoring requirements. And so I think both of them need to be considered there. It's to me what is happening as I read these five assault weapon decisions, is that the focus is much more on the burden on Second Amendment interests than it is on the effectiveness of the legislation. I mean, there are some. There was just a recent study that was published in one of the criminology journals that said that assault weapon bans were ineffective in deterring casualties in mass shootings. The focus there was instead on the so-called large capacity magazines that come with them. But I think that I would like to see the courts address more the question of effectiveness of the regulation. I think they leave that pretty much, they defer that in the very mild form of intermediate scrutiny that they've been applying. I think that's pretty much a matter on which they defer to the legislative branches. And then when they get to the burden on the Second Amendment interests, they address the question of whether an assault weapon ban burdens those people who want to use assault weapons for self-defense. And the general strategy, at least in these decisions, has been to discount the use and usefulness of AR-15s for self-defense, and I address that in my article. I think that's again an erroneous assumption made by the courts here. I think that the Werman court said that using an AR-15 for self-defense is like using a sledgehammer to crack a walnut. So I don't, I think they're way off base on that, and that's the latter part of my very end part of my article when I address that. I am actually working now on an article on assault weapons and self-defense, so we'll explore that a little more extensively there.
Fascinating. Well, maybe we'll have you on for the next one when that article comes out. So thanks for being here today. I found this discussion really fun. Always enjoy engaging with you over these issues, and really recommend your new article to folks who are looking for something to read on this topic. So thanks for being here today, Greg.
Thanks for having me.
Of course. And thanks to all of you at home for joining us for another one of our scholarship highlight series. Check out the other ones on our website at firearmslaw.duke.edu. Thanks very much.